Hello and welcome to another video in the Let's Talk Human Rights video series by the Maastricht Centre for Human Rights. I'm Sally Thin and I will be your host. Now, almost all of us use social media, whether that's Facebook, Twitter, Instagram or other platforms. Many of us are dependent on these platforms for work, for social life, for knowing what's going on in the world. But we all know that there is, or at least can be, a dark side to life on the internet. Hate speech and other offensive content are never far away from the news. So how can we regulate the use of social media, the use of these kinds of platforms, so as to protect all human rights, including the freedom of expression? And whose responsibility is this? With me today to discuss this tricky and complex issue, we have two PhD candidates from Maastricht University, Stevi Kitsu and Valentina Kolinova. Valentina, would you like to introduce yourself?
Sure. I'm a third-year PhD candidate in European law at Maastricht University. I'm also part of the research project Transformative Effects of Globalization on Law, which brings together 4 Dutch universities and is funded by the Ministry of Education of the Netherlands. And my research concerns the issues of liability of online platforms, and particularly how the advance of algorithms used by platforms to moderate content affects and even erodes the current regime of this liability, impacts freedom of expression of internet users.
Stevi?
Hi, my name is Stevi Kitsu. I joined the Department of International European Law last September. I originally come from Greece. I'm a lawyer also. And after some years of practicing in the human rights field, in NGOs and human rights institutions, I embarked on this long, strenuous, but absolutely rewarding journey that is called PhD studies. I hold a Bachelor of Laws from Aristotle University Thessaloniki, a Master's in Media and Cultural Studies from Sussex University, and an LLM in Public International Law from the University of Athens. And actually, thank you very much for giving us the opportunity to have this conversation today. I'm very looking forward to it.
All right, it's great to have you both. Now, as I understand from both of you, you've both worked, you've worked as a lawyer, you've both worked for NGOs before. What is it that got you into research? What is it that made you want to research these topics? Yeah, Stevi?
Okay. Well, I would say that I would put it the other way around. I mean, if it wasn't for the specific topic, probably I wouldn't be here today having this conversation. I'm very involved in this project in the sense that I've worked a lot in the field, but I realized that I couldn't really answer the questions I had in mind. So I thought probably pursuing a PhD would be a great idea to pose my own questions. The same way, if it wasn't for human rights, I wouldn't probably do law in the first place. So I think that all my background and, of course, the very reason that I come from a country where human rights protection has been challenged a lot from time to time has shaped who I am and inspired me to do this specific project.
And how about you, Valentina? Do you also have kind of big questions that you wanted to pose and answer, or some other kind of reason?
Absolutely. I guess I've always been fascinated by digital transformations and the way they can affect the life of us ordinary human beings. And back in 2012, when I didn't even start studying law, I became obsessed with Aaron Swartz. And for those who don't know him, he was an IT specialist from the US, but also an activist who advocated for free internet and the reforms to copyright that would actually help foster the open access to materials that could be of interest to the general public. And of course, I was really, really disappointed when I found out that he was charged with wire fraud and he later committed suicide. And I was also really excited by Edward Snowden's revelations. And when I already entered the law school, I also had a chance to participate in the JESSOP competition on international law. And for those who don't know, JESSOP is a moot court competition that allows students to plead a case before a mock court, mock tribunal. And what we did is that we pled a case based on Snowden's revelations. And that's actually helped me explore this issue and realize that this is the field that I actually would like to be part of. And afterwards, when I finished my master's, I had a chance to do research and to become part of Maastricht University. And back then, I also came across the interview given by Sarah Roberts, who just had her book published. And the book was about the content moderators that actually had to bear very strenuous and very sometimes even horrendous obligations, moderating all these harmful and disturbing content. And Sarah Roberts was asked whether she believed that her research would also be relevant nowadays when AI is being actively deployed by social media platforms. So basically, human moderators would no longer have to suffer. And as far as I remember, Sarah was very, very critical of that, because she already believed that it is not possible to simply delegate all the tasks that were previously performed by human moderators to algorithms and automated systems without actually bringing structural changes to the whole content moderation ecosystem. And I realized that this is the issue that I would like to focus on, and so that is how I embarked on my PhD research.
I think we'll definitely get more into some of that very soon. I wanted to start by kind of quite generally asking you what you think the biggest challenges are of protecting human rights online, because you both research in kind of different sides of the issue of human rights on social media and on these online platforms. So from a very general perspective, what do you think are the biggest challenges there?
My research examines hate speech on social media, focusing on the EU approach. So, of course, hate speech is not a European issue, it's not a European phenomenon, but I focus on the EU because of the European Union's long tradition in fundamental rights protection, and because I also believe that this issue can better be tackled on a European level. So we can go into details later on if you want, but I think one of the greatest challenges when it comes to hate speech is the very question, what actually hate speech is. I mean, the definition of the concept itself. I think it's very telling what Roger Kiska said about this, that hate speech at the end of the day is whatever people want it to be. So, of course, this is very debatable, but it is very telling on the controversies that exist on the specific matter. And of course, this makes sense because it touches upon fundamental rights as freedom of expression, human dignity, democracy, equality, no discrimination. So, of course, it is a concept that it is very triggering for both states and private actors. And apart from defining it, which is for me the greatest challenge, then of course we come to questions like who has to define what hate speech is? Or do we need actually to define it? Because for now we can say that hate speech is very context and content related, and all the approaches that have existed so far, they tried actually not to alienate hate speech from social and historical nuances, and it cannot be seen, of course, in a historical vacuum. This is the reason, for example, because that we have very different approach to the matter in the EU rather than to the USA. We have the libertarian model in the US, we have the First Amendment, while on the EU we are more fond of regulating hate speech. So this is a very first and superficial approach, but I think that at some point it outlines the basic questions when it comes to hate speech, and of course then we can also pose more questions on hate speech on social media.
And is this the kind of definitional question? So what content should be allowed and what content shouldn't be allowed? Is that something that you also deal with in the context of algorithms, Valentina?
Definitely, because when it comes to algorithmic content moderation, when the tasks of moderating content are basically outsourced to these automated systems, the question arises how we actually explain to these systems which content is illegal and which one actually constitutes certain lawful information that should be actually left up on the platforms. And it is very difficult to do that because automated systems are, so to speak, context blind. So they cannot understand the surrounding context around a certain message or post. That is why we always have to deal with the inaccurate outcomes of algorithmic systems. And sometimes it can be something hilarious. So for example, one time Twitter users could not post the word Memphis on Twitter. And no one knows why. So Twitter just randomly blocked this word. And users could not even discuss certain sport events. But sometimes, of course, it has very, very detrimental effects. So, for example, we can think about the footage of war crimes in Syria that were also posted on social media, but then were taken down by a wide range of social media platforms, because automated systems that these platforms deployed actually considered this extremist content, and they did not, of course, they could not understand the crucial difference between content targeted at, let's say, spreading the war propaganda and content that might be crucial as part of the evidence before an international tribunal that would deal with these war crimes. And so that is why, of course, we have the definitions of illegal content. So Stevi would also hopefully contribute a lot to the ongoing debates. But another question is how we actually feed these definitions to automated systems. And that is something that we haven't figured out yet.
And how much human input is there in these systems? So as I understand it from a very general perspective, this used to be, as you were saying before, done by moderators. So people who were kind of sitting, looking at the content and deciding what to take down. Is there any of that now in terms of human input, or is it all done essentially by computers?
Definitely. So most social media platforms deploy the combination of human moderation and automated moderation. And what we could see during the COVID-19 pandemic, for example, is that this ratio was actually swayed quite a bit, because when the pandemic broke out, many human moderators could no longer perform their tasks because for privacy reasons, they could not take their content moderation tasks home. And that is why platforms had to resort to the increased use of automated systems in order to keep taking down illegal content. But of course, when we look at transparency reports of 2020 and 2021, we could clearly see that this resulted in a greater amount of legal content being taken down. Obviously, because these automated systems are far from accurate. Moreover, they can also be biased. And what is even more troubling is that they're not always transparent. Basically, they're opaque. And it's very hard to also pinpoint the exact reason why they are so inaccurate and how we can improve the accuracy rates. So these are the issues that, of course, platforms would have to keep thinking about moving forward.
And when we're talking about the content here that is being taken down, or that we maybe think should be taken down, and vice versa, are we purely talking about illegal content? So, Stevi, you're talking about hate speech, or are we also here kind of straying into what we consider to be offensive or immoral content? And what's the relationship between those two?
So this is a great question, and actually it is one of the greatest challenges that not only big tech entities have to deal with, but also policymakers. And informations and ideas are protected by the freedom of expression. And actually the informations and the ideas that are protected are not those who are favorably perceived by the state or the population, but actually those who can shock, disturb or offend. And this is actually the opinion of the European Court of Human Rights in the seminal case of Handyside versus UK. So let's start that from the very starting point, that the freedom of expression has to upheld, and this is a balancing of rights that the court has to do. On the other hand, hate speech is not protected by the court. And this is a proven experience by the very fact that there is Article 17 of the Convention, that when there is manifestly illegal hate speech, then the court considers the case inadmissible, and then with the reference of Article 17, it rejects it as an abuse of rights. So what is hate speech, though? Although it is a very big conversation, for now we could say that any speech that incites to violence or hatred is illegal. Of course, then the question arises, all right, but still harmful hate speech is out there, and this is what actually erodes social cohesion. And we have minorities, we have the rights of minorities, we have the rise of the extreme right wing. There's so much at stake to consider when we talk about hate speech. Well, I think that everything that matters here is the starting point that someone can begin this conversation. So depending on your ideological beliefs and, of course, your legal traditions, you could find different answers to the questions. So we have, especially in the Council of Europe and in the European Union legal framework, many theoretical and ideological approaches, be it the militant democracy doctrine, the Speech Act theory, the critical race theory, the harm-based effect. So the thing is that, and also these ideologies apply to the American approach to the matter. I would say that everything matters on who we are at the end of the day. The power imbalances and the power structures, and how we can influence other, not only minorities or oppressed groups, but in the social hierarchy where we find ourselves. So when it comes to harmful hate speech, because it is still hate speech, this is where I think private entities come in, and this is where they decide based on their community guidelines, which are not necessarily in line with the EU framework on their national standards. And this is highly problematic in my view.
So many big questions there as to what content should be allowed or is allowed. And I suppose it, for me, begs the question in relation to your research, Valentina, are algorithms capable of doing this? Can they make those kinds of calls? How, if at all, is it possible to input that kind of information into that kind of system?
I think the answer to this question would be rather straightforward. No, algorithms cannot do that. And I think that's actually a trap that the EU legislator has fallen into, assuming that it is actually possible to instruct platforms to automate all their content moderation processes, as if it is a silver bullet against the availability of illegal content online. So what we see is that the EU legislator continuously strives to encourage or even oblige social media platforms to proactively monitor the user-generated content stored on their servers in its entirety to make sure that they weed out the infringements without even waiting for an injunction, let's say, issued by a public authority, or a notification or a complaint issued submitted by one of their users. But we have to keep in mind that whenever we say that, okay, you social media platform, you really have to be proactive. You can no longer use this hands-off approach that you're used to. You have to step in and you have to be very vigilant of the third-party content that you transmit and store. Then we also encourage the so-called over-removal of legitimate content, which inevitably occurs when social media platform has to scroll through all the materials that are posted by their users and has to take action on every potentially illegal material. Because if we look at the e-commerce directive, and this is the primary legitimate instrument that I analyze in my thesis, we see that social media platforms enjoy the exemption from liability when they do not have knowledge of illegal content, but do act expeditiously to remove it when they gain such knowledge. But of course, when the social media platform constantly monitors and investigates the content that it hosts, then it would inevitably gain such knowledge and would be inclined to remove a little bit too much rather than too little, in order to ensure that it can still avoid liability. And this is what I call the better safe and sorry consequence of this situation. Because of course, every platform is also a business entity. So it is normal that they wish to also minimize their business risks. That is why it's much easier for them to take down certain legal content by means of algorithms and avoid thinking about these complex issues relating to freedom of expression. That is why the delegation of content moderation tasks to automated systems is tricky, because it does not only implicate these technical shortcomings of systems themselves, but it also undermines the entire legal framework that we have put in place some time ago. And the EU legislator, in my opinion, is not always mindful of these consequences.
Can I be a bit of a devil's advocate here? So, I mean, of course, what we understand is that social media platforms have become like the new public sphere, as Habermas had coined back then. And so great things can happen here. Just consider the Me Too movement. Let's consider all the public participation, how powerful citizens can be because they have a platform of their own and they can express their views. And of course, we also witness at the same time that these are the very platforms where hate speech proliferates, where scandals like the Cambridge Analytica was revealed, and not, of course, to mention the genocides and the propaganda that has been orchestrated by states or even private entities. So maybe we should think that if social media are to be that powerful, then they need to take responsibility of this power, because this is how it goes. And what I agree on, and I think that you also agree on that, is that they need some clear guidance. So we need a common framework. If we are to talk about the EU, we need to talk about the EU framework, EU common approach on that. Because as you also said, the Digital Services Act, for example, it only provides for procedural safeguards, and it does not really go into the essence, like what is hate speech, what is illegal content, and how can we act against this. But this is something that, in my view, has to happen as soon as possible, because even now, and we can take Germany as an example with the German Network Enforcement Act, even though that the country threatens social media with very hefty fines, and it has received very intense criticism on that, at the very same time, we can see that social media favor their internal system in flagging the content in order to be taken down rather than the national regulation. So they also need to abide by some rules. And it also seems that the self-regulation model that is currently in place, and I'm talking about the EU Code of Conduct on countering illegal content, hate speech actually, is not enough, does not suffice. So I think that we need to have a common ground, and I totally agree with Valentina that this can be approached probably by EU common framework, clear framework.
I do agree with you, Stevi, and you raise a lot of important issues, but at the same time, I think we have to be mindful that when we clamp down on social media platforms that obviously have created this whole system of surveillance capitalism. I'm sure that you're aware of this very popular book by Shoshana Zuboff from Harvard University. At the same time, we should be mindful that when we do ask social media platforms to do a little bit more, to carry more responsibility, we might also punish individuals and in particular marginalized groups that also take to these platforms to be heard and to speak out and to oppose the governments or raise awareness about certain fundamental societal issues. And this is not always the case in the EU. So the EU legislator, in my opinion, is not always aware of these potential consequences. So as I said before, algorithms and content moderation are considered as silver bullets. So they're considered rational, accurate, and fit for purpose. And what I also see a lot is that the EU representatives always argue that, oh yeah, so perhaps it is not that important that we take 1% of legitimate content as a result of our fight against hate speech. Because what would it matter, basically? So since we have this legitimate goal and we have this very compelling ground to act, why wouldn't we sacrifice just a little bit of legitimate materials and actually get rid of all hate speech? Wouldn't it be the rational price that we would be willing to pay? And I also just try to confront this very quantitative approach to hate speech in my to freedom of expression in my thesis, because when we do change our framework, and in particular the e-commerce directive, these very foundations of the liability of online platforms, we also have more pervasive issues. So for example, we can think about the private ordering. So this happens when social media platforms take on the tasks that are performed by public authorities, and they become the substitute for legislative, executive, and judicial organs of the state. So, of course, we might also ask ourselves whether this is even legitimate, whether social media platforms, being private entities, are up for this task. Would we actually be willing to delegate these tasks to them? Or, of course, we can think about the problem of chilling effects. So when the EU citizens see these changes to EU law, and they see that social media platforms are obliged to monitor the content that they post and proactively take down the potential infringements, of course, they might also be less inclined to speak out, because they would have this fear that social media platforms would actually take everything down, and they believe that, okay, so that might not make sense at the moment, because what would happen if my speech is actually taken down? So a lot of people become worried about this potential consequence. And when we try to clamp down on hate speech, I think we always have to be mindful of the broader spectrum of consequences that it might bring about for freedom of expression.
That's maybe quite an interesting question then, because I think what's coming out of this for me is this idea that because of the way that the online space has developed, these social media platforms, these online entities, have power that makes them different from private actors that we've seen previously. And by asking them to take down and to moderate this content, we're asking them to take on almost a public function that they may or may not be ready for, be capable of doing. Do you think that I suppose, because I don't know if I'm interpreting what you just said incorrectly here, but it sounds like you were saying you don't think they are capable of doing that?
I'll start saying that the EU has to decide what social media, what wants social media to do, because when you have like self-regulation approaches like the EU Code of Conduct, then of course you give adjudicatory powers to private entities while it is not their position to do so. So I agree with Valentina that this is where the problem starts, and I hope that the Digital Services site will try to solve this issue. I'm not sure if hard regulation is what we need here, but I'm confident that what is currently in place is not enough. So I think that the EU has to step in, and I think it has already demonstrated its willingness to do so. So it remains to be seen.
So they certainly have a role, but there needs to be more from the real public entities, so to speak.
This is my view.
Valentina?
I do agree, because indeed I think it is inevitable that we would have to order social media platforms and expect them to take down illegal content, because this entire technical infrastructure lies within their hands. And public authorities normally do not have access to the servers where this user-generated content is stored. But indeed, I fully agree with Stevi, who mentioned that public authorities cannot exercise this very hands-off approach and say that, oh yeah, I want you to be good, and if you're not good, you will incur penalties. And then social media platforms are actually very confused because, of course, being business entities, they do not have this knowledge of how the law should apply and how to distinguish hate speech from, let's say, legitimate criticism of the government or other social society groups.
Yeah, there are so many.
And we've, I suppose we've mentioned freedom of expression a lot, and we've mentioned kind of in perhaps more vague terms that we're the rationale behind things like hate speech regulation and content regulation is to protect people from that content. What other rights are we talking about here? Is it mainly a question of freedom of expression, or are we also talking about the rights of other users or other actors?
Absolutely. So we do have a plethora of fundamental rights enjoyed by different stakeholders. Of course, first of all, we have to think of the state. So I mentioned that, of course, the role of the state is becoming weaker and weaker every year. But we have to keep in mind that the state still has to ensure that all individuals within its jurisdiction enjoy the right to security or the right to privacy. So what I'm saying is that states have to make sure that individuals do not encounter illegal contents that might breach these rights. And they also have the positive obligation to put in place certain measures, certain legislative instruments that would then compel social media platforms to do something about that. And these rights can also be found under the European Convention on Human Rights and the Charter of Fundamental Rights of the EU. Of course, we also have to think about platforms themselves, because under Article 16 of the Charter of Fundamental Rights of the EU, we would find the right to freedom to conduct business. And this is also something that the states have to keep in mind when putting in place those legislative measures, because they do have to ensure that the individuals are protected against the unrestricted amounts and availability of illegal content online. But they cannot put an excessive burden on the platform's shoulders, because they, as business entities, have the right to also carry out their entrepreneurial activities. And that is why they cannot just be expected to weed out every single piece of illegal content stored by their users. So I would say that these are the rights that have to be balanced. But of course, another question is how we strike a fair balance between these rights. And I guess we always have to prioritize certain rights in order to achieve a viable solution, because the Charter of Fundamental Rights of the EU, of course, does not envision that the certain rights have a priority over other rights. But I guess in practice, we always have to make certain decisions and to do say that, yes, we, for example, are ready to double down on freedom of expression, or, oh yeah, we are ready to prioritize the right to security. But this is the choice that I guess hasn't been made yet in the EU, but we will see what decisions will be made in the future and what rights will prevail.
And it's a balancing act that you think shouldn't be done by algorithms.
Citizens trust states that they would be treated equally. They would have equal status, and they will not become victims of discrimination. So when states allow for illegal hate speech to take place, this undermines human dignity. And of course, it is one of the most fundamental rights that we all enjoy. And this is something that states who should also take into consideration when it comes to hate speech regulation. This is something we should always bear in mind when we try to approach, define, regulate hate speech. And this is something that we all need to examine.
So it sounds like here there are loads of different difficult aspects of this problem. So we have, how do we define this content that should be taken down or that should be considered as hate speech? Who should do it? How should it be done? Are you optimistic that this is a problem that can be solved in the coming future?
To a certain extent, yes. And I would like to refer to this legislative proposal that Stevi already mentioned, which is known as the Digital Services Act. And the proposal was tabled by the Commission in December 2020. What we could see in this proposal is that the EU legislator was reluctant to actually abandon these foundations of the platform's liability that I was talking about that are now enshrined under the e-commerce directive. And I guess this is already a very good step because the EU legislator did not instruct platforms to continuously monitor their servers in search of illegal content. And I guess that is also a sign that the EU legislator is mindful of the consequences that this policy change could bring about. But of course, there is still a lot of work to be done. So the Digital Services Act does not really provide any meaningful safeguards against the inaccurate or biased algorithmic outcomes. So it does mention that platforms can deploy certain algorithms if they consider that necessary, but it does not really outline how platforms can really mitigate the risks and the negative outcomes of these systems. Of course, we also have another legislative proposal, which is known as AI Acts, which would also hopefully provide certain clarifications in that regard. But I guess in order to ensure certain consistency within this very wide number of proposals, we should also make sure that the Digital Services Act has a word on that. Otherwise, platforms, by looking at this proposal, might also decide that, oh yes, there is not that much that we have to implement. So we can also just choose to implement these algorithms and then not worry about the consequences. So I guess this is not going to be a desirable outcome, and that is why I am hopeful that by the time it is adopted, the Digital Services Act would actually stipulate these safeguards. But I guess the time will show.
Is this something that you would like, I guess, kind of everyday people to know more about and to pay more attention to?
Absolutely, because it is going to concern every individual that uses the information society services provided by platforms. And of course, we always have to be very attentive to what is going on this legislative arena in the EU. And we have to resist certain negative trends that sometimes are also surfaced within the EU. And with that, I would also like to give an example of one of the most debatable legislative acts, which is, for example, the terrorist content regulation that also already entered into force last year. And this terrorist content regulation actually adopts a very different approach than the one envisioned in the Digital Services Act, because it does require platforms to put in place proactive measures to counter the availability of terrorist propaganda on their servers. And I think, of course, a lot of platforms would like to automate these activities, even though the terrorist content regulation does not explicitly ask providers to deploy algorithms for this task. But of course, it is not feasible for social media platforms to always proactively discover these materials manually, and they would resort to algorithms to facilitate this search. And I guess this is not something that's desirable from the fundamental rights point of view. And I guess maybe if the civil society had also been a little bit more vigilant of that and a little bit more active in this respect, we could have avoided it. Of course, there was a giant public outcry, and a lot of activists were actually opposing these legislative instruments. But at the same time, a lot of people are not even aware of the availability of this law and of the fact that this law has recently been adopted. And in order to prevent the future instruments that might also impact our freedom of expression negatively, we all have to be very careful about what the EU legislator does, and we always have to keep an eye on all the developments.
So it sounds like we have a bit of a warning there, cautious optimism, but optimism nonetheless. Stevi, optimist?
Yes, to some extent, I share your optimism. I would say that it's very promising that the EU has acknowledged that the current framework is not enough. be it hard law like the framework decision, the 2000 framework decision, which is actually now in place. And it is the only legal binding document we have in our hands. In the EU, be it a soft law instrument like the EU Code of Conduct. But it has demonstrated its commitment to protecting human rights and fundamental rights of EU citizens. We have the Democracy Action Plan, the Anti-Racism Action Plan that should be seen in parallel with the Digital Services Act. And I think that an EU approach based on these considerations should pave the way actually in order to have a safe and equal for all participation on social media.
Sounds like we kind of finishing up there with, again, cautious optimism. Thank you very much, both of you, for coming. I think we've had a really interesting conversation today. Hopefully everyone at home thinks the same. I always try and finish these videos with a quick question, to be as serious or as silly as you like. If you could add one new human right to human rights law, what would it be? Valentina, we'll start with you.
I would go for the human right to travel around the world without any visa restrictions or any other formalities. Because I think that traveling really helps people broaden their horizons and become aware of the diversity that we have in our world. And in my opinion, this is also a way to tackle hatred and violence that we always see happening. Because, of course, if people are not really familiar with something or someone who is different from them, they tend to overreact. They tend to be very critical. But that doesn't mean that they are necessarily very evil deep down. That does simply mean that it is something that they're not used to. That is why they might be a little bit anxious or scared about it. But by traveling around the world, having an opportunity to see other countries without bearing significant costs or burdens would actually help people become more open-minded and less hateful.
So kind of tackling the fear of the unknown by a right to no borders. I love
exactly.
that. Stevi.
I would second that. Absolutely. Well, I've considered many rights that could be added to a full suite of human rights, but I think that the problem we have right now, the problem we witness, is not that we don't have enough human rights in order to protect, but that the existing ones are not effectively protected. So, especially given the current situation, I think that we should be very aware of who we are, what we say, who exerts the power, and the interests that are in place. So, yeah, but if I would go for a human right, I would just join Valentina's because I completely agree with that. Yeah.
Wonderful. Okay then, once again, thank you very much. Given your reservations about social media and the online space, you may not, I don't know how active you are on social media yourselves, but if people want to find out more about yourselves and your research, where can they find you, Valentina?
Yes, so I invite everyone who's interested to follow me on Twitter, where I sometimes post some short reflections on the current events or on the ongoing debates on platform governance and internet law. I also write blog posts for different platforms, for example, for FASUM's blog or EU Law Live. And if you want to find all of these blog posts, you can also access my profile page at Maastricht University, and you will find all of these contributions combined there. And I also invite everyone to follow the network that I'm part of. It's called GLONET, Globalization and Law Network, if you're interested in more compelling and interesting strands of research that my colleagues are busy with.
Stevie?
I'm on Facebook and on Twitter, not that active on Twitter, I have to admit. But you can find as much information as you need about myself on my profile page at the Maastricht University webpage, and at the Maastricht Center for European Law. So thank you very much for this opportunity. I really enjoyed this conversation.
Thank you. I did as well.
Thank you.
And as always, you can always find out more information about what is going on at the Maastricht Center for Human Rights on the website. And yeah, keep up to date as to what's going on within the centre and in this project. And thank you very much for joining us. We'll see you next time.